Okay, Olha's is that acceptable? I didn't think so.
Have a good rest of the night. It was really fun, wasn't it? Really relaxing. For the first time since you've been here.
Okay. Good afternoon to everybody here. Thank you for coming. We're just going to say a few brief words before we get started. Kate?
First of all, thank everyone for their patience. We're so excited about the final round. All of the competitors from all 46 of the teams have been just fabulous, and we've heard nothing but fabulous feedback from all of our judges. But here we are with our two top teams, and we're all looking forward to a fantastic final round. Our final round bench, as you see in the program, we're lucky to have the Honorable Harold Baer, who's a judge for the Southern District of New York. Professor Lenny Benson, who is our in-house immigration expert, nationally known in the field, so she'll be on you for that second issue. Deputy Secretary of Labor Seth Harris, who was recently appointed to his position by the Obama administration. We're excited to have him as well. Our own Dean and President of New York Law School, Richard Mattisar, and Mr. Ronald Meisberg, who is the General Counsel for the National Labor Relations Board. So without further ado, they are here. We're all excited, and good luck to everyone.
Just a quick thing. For those of you who heard our comments upstairs, I'm sorry if this is repetitive, but again, we'd like to thank Joshua Hoffman and Jeff Linehan, who were the co-authors of the fact pattern, and this whole competition really could not have happened without them, because without a fact pattern, we wouldn't have had any competitors here. And also to Hannah Faddis and Sandra Dubow, who are the executive editors, and of course to all of our moot court members and executive board who have worked tirelessly over the last few days to help us have this competition run as smoothly as it has, and it really has. So it's a testament to all of us. So thank you.
Thank you.
Oh, and please turn your cell phones off. Thank you.
Oyez, oyez, oyez. All those who have business before this, the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. The Supreme Court of the United States is now in session. Justices Benson, Meisberg, Harris, Mattisar, and Chief Justice Baer presiding.
Very exciting. We don't have a bailiff that loud.
The first case on the calendar this 14th day of March is Wagner Incorporated petitioner against Anjali Mehta respondent.
You know, I left my glasses. That'll be fun.
Would you like us to?
I forgot my glasses. You can all be seated. But if you find my glasses, I'd like them. If you don't find them, I think I know it. I think we're ready for the first Arguer?
Mr. Chief Justice, Your Honors, and may it please the Court. My name is Nick Gibson, and I, along with my co-counsel, Ellen Wesley, represent the petitioner, Wagner Incorporated. At this time, may I please request 2 minutes for rebuttal?
You may.
Thank you.
And you may even get it.
Your Honors, there are 2 issues before the Court today. The first issue, which I will address, involves the Age Discrimination Act burden of proof. And the second issue, which my co-counsel will address, involves damages under the Age Discrimination Act. Petitioner respectfully requests this Court reverse the decision of the 13th Circuit and reinstate the District Court's grant of summary judgment. Moving to the first issue, Maida failed to meet the burden of proof to survive summary judgment on her age discrimination claim for 2 reasons. First, this Court's decision in Gross applies, and Maida failed to demonstrate that age was the but-for reason of her discharge. And second, Maida's evidence is simply insufficient for a reasonable jury to find in her favor at trial, and therefore summary judgment is proper. Turning to my first point, Gross controls the resolution of this case. This Court was very clear in Gross that a plaintiff bringing a disparate treatment claim under the Age Discrimination Act must prove that age was the but-for reason of the discharge.
That's not the circuit's view, albeit I realize we're not responsible for the circuits. But indeed, some of the circuits have a little looser kind of test, don't they?
Your Honor, this Court has held that an ADEA plaintiff must prove that age was the but-for reason of the discharge. Some circuits do apply the McDonnell-Douglas evidentiary framework along with the Gross framework, but at the end of the day, the plaintiff must demonstrate that age was the but-for reason of the discharge for a jury to find for that party.
And does it matter whether or not it's the whole, for instance, if the whole group of people that were discharged were all older than the ones that were left? Would that be a but-for reason that would satisfy us?
No, Your Honor. In fact, that is one of the categories of evidence which the plaintiff brought forth. And when the sum total of the evidence is even viewed in the light most favorable to the plaintiff in this case, it is insufficient for a reasonable jury to find that age was the but-for reason. In this case, we're determining whether age was the but-for reason, whether she was intentionally discriminated against because of her age, not whether there was a disparate impact across all older workers in this case.
What evidence would be sufficient to survive a summary judgment motion? Can you give us an illustration of what would, at the stage of pleading and generation of evidence, what would be enough to survive summary judgment under your view?
Your Honor, in this case, plaintiff brought forward statistics regarding the reduction in force that were not regarding the similarly situated employees. If she had brought forth statistics regarding similarly situated employees that demonstrated an age imbalance, that might be probative, along with comments that were actually...
This is a treatment case, so are those statistics relevant, really?
Your Honor, statistics are still relevant evidence. However, in this case, plaintiff failed to bring forth statistics that involved her job position that were probative of but-for causation.
So short of her finding somebody who said, gee, you're getting a can because you're old, what could she show?
She could also bring forth comparative evidence that perhaps she was more qualified than the employees that were retained.
However, there isn't any question, is there, but that she meets the other tests, or at least the McDonnell-Douglas prongs, that she was qualified for this role, or do you have some question about that?
Could you repeat your question, Your Honor?
There isn't any question in your mind, is there, that she was qualified under the McDonnell-Douglas four-prong approach, which you're not anxious to use?
Your Honor, there is no question whether she was qualified. However, even if McDonnell-Douglas were applied, and even if she was able to establish a prima facie case, the inference of discrimination which the prima facie case establishes was instantly dispelled once Wagner came forth with its legitimate non-discriminatory reason. So the question really becomes one of pretext and one of what evidence has she brought forward. And here, the 3 categories of evidence which she brought forward were insufficient individually and collectively for a reasonable jury to find at trial that age was the but-for reason of the discharge.
Excuse me, counsel, you don't think the jury should have an opportunity to evaluate, given the totality of the circumstances here, the statements about youthful culture, more energy, requirement of attending youthful events, that there was a culture in this corporation that favored the young? You don't think that there was sufficient evidence for it to go before the jury?
No, Your Honor. That what you're referencing is the Get Well, Feel Younger campaign, which was one of 3 categories of evidence brought forth by Dr. Maida in this case. However, Maida failed to bring forth any evidence indicating that there was an intrinsically age-related employment policy affected by the Get Well Feel Younger campaign. The Age Discrimination Act makes it unlawful for an employer to discharge an employee because of age or adversely affect the employee because of age. However, it does not make it unlawful to create marketing campaigns based on its own anti-aging products or motivating its employees to back those products. And lack of evidence brought forward, failure to bring forth evidence that does connect the dots and demonstrate that there's an intrinsically age-related employment policy
I'm not
affecting.
sure I understand what you're saying. As I understand the record here, that the company kept those who were 35 and let go those who averaged 44. You don't think that shows a discriminatory animus?
No, Your Honor, because what you're referencing is the lab technician pool of employees.
Right.
However, in this case, Maida was a chief lab technician and was not similarly situated.
Well, I'm including them. They were included in that group for which that was the 35 and 44 with the numbers. They weren't all chiefs, obviously. There are too many chiefs all over anyway.
Respectfully, Your Honor, there were 6 chief lab technicians, and the average age statistic that you're referencing only references the lab technicians and not the chief lab technician pool. Within the chief lab technicians, there were 6 chief lab technicians before the reduction in force, 4 over the age of 40, 2 under the age of 40. After the reduction in force, there were 3 chief lab technicians retained, 2 over 40 and 1 under 40.
Let me ask you a question about lab technicians. When this Ms. Maida was hired, her visa stipulated that she was going to be heading up some research, right? Chief researcher?
Correct, Your Honor. She was hired originally as co-director.
And her visa did not stipulate that she would be doing the lab technician job. Is that correct?
Correct, Your Honor.
What should you have done when she was no longer going to be in the job for which her visa was granted? Should you not have discharged her at that time?
Your Honor, Wagner should have discharged her. However, the facts in this case are that Wagner retained her as chief lab technician, and she accepted the position and continued working for Wagner in that position.
Is she qualified for that position since she's not legally here under that visa?
Your Honor, my co-counsel will address the authorized or unauthorized status of Dr. Maida regarding the job
But
position
it's a
changes.
qualified, but qualified is one of the 4 McDonnell-Douglas tests.
Well, he already agreed that she was qualified, I thought, right?
Correct, Your Honor. Even if we concede that the prima facie case is fulfilled, the legitimate non-discriminatory reason given by Wagner dispels this inference that the prima facie case creates, and then the question becomes one of pretext and one of evidence.
Counsel, are you arguing that once a legitimate non-discriminatory reason is presented by the defendant, that the presumption explodes and has no role in the case at all?
Your Honor, the prima facie case only creates an inference of discrimination, and this inference...
It creates a presumption. It creates a legally mandatory presumption, which in the absence of a legitimate non-discriminatory reason entitles the plaintiff to a directed verdict or to summary judgment. So are you arguing that the legitimate non-discriminatory reason causes the presumption to explode and have no evidentiary value in the case at all? Is that your position?
Under the McDonnell-Douglas test, Your Honor, the plaintiff then, after the legitimate non-discriminatory reason is given, has an opportunity to come forward and demonstrate evidence of pretext. And under Gross, this level of pretext must rise to whether age was the but-for reason of the discharge.
Well, I think you're mixing apples and oranges with respect to Gross. The difference between a Price-Waterhouse mixed motive case and a McDonnell-Douglas case is the difference between 2 motives and 1. Right? McDonnell-Douglas is about single motive cases. So by definition, McDonnell-Douglas is always about a but-for cause. But I want to go back to this question about presumption. Are you acknowledging that the presumption remains in the case as relevant evidence even if there is a legitimate non-discriminatory reason offered?
No, Your Honor, because once the legitimate non-discriminatory reason is presented, that inference is dispelled, and then the plaintiff has an opportunity with a factual certainty that's framed by the legitimate non-discriminatory reason to come forth with evidence, bring forth evidence in this case that age was the but-for reason of the discharge. And the summary...
Whose burden of proof is it?
Excuse me, Your Honor?
Whose burden of proof is it on the pretext issue?
On the pretext issue, it's the plaintiff's burden to bring forth evidence of pretext. The ultimate burden of persuasion always remains with the plaintiff under Gross, and the plaintiff must always demonstrate that age was the but-for reason of the discharge. At the summary judgment stage, the plaintiff must present sufficient evidence such that a reasonable jury could find that age was the but-for reason, but in this case, the evidence was insufficient.
Why can't we let the jury infer from the fact of the age differentials involved in who's retained and who's fired that age was the but-for cause? Why would we want to take that question of inference, which is a jury question, away from the jury?
Your Honor, because this court in Mayor Philadelphia held that statistics must reference the relevant universe or similarly situated group. And here, Maida's attempt...
We don't have to rely on statistics, right? We can just look at the facts. It doesn't have to be a statistically valid analysis in the disparate treatment cases, Judge Matisar said. We can just simply look at the fact that your client kept younger people and fired the older person. Or disadvantaged the older person, I should say.
Respectfully, no, Your Honor, because Dr. Maida failed to bring forth any evidence demonstrating that there were other reasons for the discharge. The statistics only indicate what the ages of the employees retained in discharge was. It doesn't bring into account any other factors, including, and most importantly, performance.
Well, that's your job, right? That's not her job.
No, the plaintiff has the opportunity to bring forth this evidence in the discovery process and so forth. She has the burden to bring forth the evidence, and her evidence is insufficient at the summary judgment level, such that a reasonable jury can find that age was the but-for reason of the discharge.
So I want to explore a little bit about reasonable juries with you for just a second. Does it matter that this is a remedial act, that it was enacted for the purposes of dealing with discrimination in the workplace? Does that have any impact at all on whether we should let the case go to the jury? So let me walk through what I can see from the record. Get well, feel younger, make you feel like a kid again. We're not going to let age be a barrier to freedom and fun. The assessment that was made of her was that her dedication and passion were missing, and that she didn't go to these monthly outings except once, where all the young people would come sing karaoke and all those things. So that's sort of one bundle of facts, combined with another bundle that tell us that there's a significant age differential between those retained and those who were let go. Why doesn't that amount to a sufficiently robust factual record to let a jury determine, under this remedial statute, whether there in fact was a but-for causation?
First, Your Honor, with regards to the remedial nature of the ADEA, this is true. However, the plaintiff still has to bring forth evidence that's sufficient for a reasonable jury to find in her favor.
I gave you about 7 pieces of evidence, and I'm just wondering why those are not sufficient.
With regard to the Get Well, Feel Younger campaign and the components of that, once again, Maida has failed to bring forth any evidence demonstrating that there's an intrinsically age-related employment policy affected by it. The ADEA does not prohibit an employer for discharging an employee for lack of attendance at outings by the employer. And the 80s karaoke night, the record does not indicate that only young people went to it. It only indicates that Maida did not attend it.
I suppose she says, I get tired easily. That's maybe age-related. And yet they want to have these late-night events that seem to be affecting the evaluation that's made of her because she doesn't show this passion. Not necessarily related to the job, is it?
Your Honor, it might not be related to the job. However, passion is not prohibited as a reason for an employer to discharge an employee under the Age Discrimination Act.
Okay, so her problem was in cross-examination. She didn't go far enough into asking what they meant by the word passion. And so what you're saying is that we should keep this case from going to a jury because they didn't explore deeply enough. Doesn't that leave, I think as Justice Harris has suggested, enough of an inference that a jury can then determine, not on the merits, and they've got to make a decision. Burden of proof, as Justice Baer says, rests on the plaintiff. But you want to take this case from the jury before the jury ever has had a chance to evaluate that evidence.
Respectfully, no, Your Honor, because all 3 categories of evidence brought forward by Maida in this case fall in Wagner's favor. The statistics demonstrate that the reduction in force was age neutral as it applied to her job class. The comments referenced by Maida were stray, as they were remote in time and context from the discharge decision, which is at question before the court today.
We accept stray comments under Title VII, right, counsel?
Your Honor, in Price Waterhouse v. Hopkins, this court held that stray comments by a non-decision maker are not probative of the plaintiff's burden in this regard. Your Honor, I see my time is up.
You can sit down. Thank you.
Good afternoon, Mr. Chief Justice, Your Honors, and may it please the Court. My name is Ellen Westley, and I, too, represent the petitioner, Wagner. As my co-counsel indicated, during my time before the Court, I will discuss the Age Discrimination in Employment Act damages issue. Your Honors, the Immigration Reform and Control Act forcefully made the combating of unlawful employment central to this nation's immigration policy. Therefore, this court should overturn the decision of the 13th Circuit and find that respondent is precluded from recovering damages under the Age Act for the following 3 reasons. First, the Immigration Reform and Control Act's substantive provisions control over the remedial provisions of other federal labor and employment statutes. Second, respondent was not authorized to work in the United States at the time of her discharge. And third, injunctive relief is sufficient to effectuate the purpose of the Age Act without infringing on the substantive provisions of the Immigration Reform and Control Act.
Did that have a Ninth Circuit came out?
Are you referring to Rivera versus NIPCO, Your Honor?
I suppose it's one that doesn't come out the way you just stated the law.
Your Honor, in that particular case, the court was not discussing whether the Hoffman plastic compounds applied to Title VII or not. The analysis in that situation of whether Hoffman should be extended to Title VII cases was merely dicta.
Ms. Wesley, the date of the Immigration Reform and Control Act is 1986. The date of the Immigration Act of 1990, which created the current statute creating the H-1B, is 1990, so 4 years after IRCA. And in the 1990 Act, it specifically says in 8 U.S.C. 1182 that employers who fail to pay the wage that they've certified in an H-1B can be sanctioned by the Department of Labor for each pay period that they do not pay the authorized wage. Why do you not view that as clear congressional intent that employers may be sanctioned for violating the H-1B and evidence that other remedies like Title VII or age discrimination should be available as well? There's a clear concern about abuse by H-1B employers, and with all due respect, it appears your client may have abused Dr. Mehta.
Your Honor, that is correct. There are sanctions under the H-1B program for employers who fail to live up to their duties as H-1B employers. In this situation, Wagner may be liable for penalties under both the H-1B program and the Immigration Reform and Control Act. However, that does not change the Hoffman holding or Congress's intent to end the magnet of employment that lures illegal aliens to this country. In Hoffman, this court was very specific that an unauthorized alien worker may not recover certain monetary damages when that unauthorized worker is not authorized to be in the United States. In Shurtan Inc. versus NLRB and later in Hoffman, this court struck a balance between federal immigration law and other important federal laws. In Hoffman, this court affirmed the balance it first outlined in Shurtan, but reached a different conclusion under a similar set of facts due to the enactment of the Immigration Reform and Control Act in 1986. And this is because the Immigration Reform Act expressly and unambiguously prohibits unauthorized alien employees from working in the United States. The 13th Circuit's assertions that the Hoffman holding is obtuse and amounts to overreaching dicta are false. The immigration policy concerns that were present in Hoffman apply in this case as well, even though this case is being decided under the Age Discrimination and Employment Act.
This case is different than Hoffman, counsel, isn't it? The big difference is that the unauthorized behavior in Hoffman was the act of the employee. The employee illegally entered, or without documentation, entered the United States. In this case, your client controlled the H-1B process. Your client submitted the LCA. Your client made the decision to transfer the respondent in this case. Your client broke the law, right? It was not the unauthorized alien as we had in the Hoffman case. So why would we read Congress's enactment in the immigration law and in the ADEA as empowering your client to violate the law and the consequences flow to the worker?
Because, Your Honor, Hoffman is still controlling in this case. The specific...
Not if it's a different case, counsel. If it's a distinguishable case, it controls not at all.
This case, yes, it is factually distinguishable from Hoffman, but the Hoffman holding was not so narrow as to preclude an unauthorized alien worker from recovering damages only when that...
It turned on two basic facts. It says here that the plaintiff was not authorized to work in the U.S. during the period for which back pay was sought, and the plaintiff had violated the law by submitting fraudulent documents. That's really not our case, is it?
And the employer in that case had no knowledge of it.
Has the NLRB uniformly applied the Hoffman holding to other statutes it enforces, or only, like for the other labor law statutes that it applies? Does the agency also take your position that Hoffman applies in all labor cases?
Yes, as the NLRB General Counsel confirmed in a memorandum after the Hoffman decision, an illegal alien worker should not seek to recover back pay damages whether the employer knew of the unlawful status or not.
But isn't there a case pending before the board right now, the Mazonos case, seeking back pay for an illegal alien in a case in which the employer wrongfully hired the alien?
Yes, Your Honor, but that case is pending before the NLRB at this time, and Hoffman remains the controlling authority on this issue. Because respondent was not authorized to work.
Ms. Wesley, Hoffman controls only if we say so, right? And so we're expressing some questions about whether it should be extended. Can you help us out as a matter of policy, why it would be good policy for this country to adopt a set of rules that would encourage employers to bring people here legally, change their employment status without necessarily filing the paperwork to keep them here legally? Would you agree that if they just amended the H-1B application to reflect her new status, she certainly could have stayed? So here's this employer that has done everything wrong, and at the end of the day, it's alleged, discriminates, and what you're suggesting is that the Congress of the United States thinks that's the right way for us to come out in applying these remedial statutes?
Yes, Your Honor, because
what's the policy that would be furthered in doing that?
Certainly, Your Honor. Respondent cannot recover any damages that represent wages she could not have lawfully earned in the United States. In Albemarle Paper Company versus Moody, this court...
She could have lawfully earned those wages had the company amended and said her job is changing here in the country.
Yes, that's correct, Your Honor. However, respondent remained in the position as chief lab technician for a period of 18 months after the transfer decision, and she even admitted in her deposition on page 16 of the record that she could have sought new employment in this country, but chose not to remain closer to her family members.
Why should your client pay for that? Why should she be here for 18 months working as your client asked her to work and not get paid for it? That's what I think our problem is, amongst others.
Your Honor, that brings me to my third point, that Wagner is not...
Before you answer that, why would Congress think that would be the right policy?
Because respondent cannot recover any damages that represent wages she could not have lawfully earned in this country. Section 1884I of the Immigration and Nationality Act defines a specialty occupation as one that requires both theoretical and practical application of a body of highly specialized knowledge and attainment of a bachelor's degree or higher in the specific specialty as a minimum for entry into the United States. As of October 16, 2006, respondent was working in a position in which she merely performed administrative duties.
Do you have any case authority that the Immigration and Naturalization Service, now the CIS, would not approve an H-1B for a chief lab technician?
No, Your Honor. However,
you're speculating about whether the agency would or would not have approved her had the company filed an amended petition.
Your Honor, the chief lab technician position did not require an attainment of a bachelor's degree or higher. It could have been performed by an American worker. However, the ultimate issue is that Dr. Maida was not working in the position as authorized by her H-1B visa at the time of her discharge.
That's your client's. I mean, the concern that we all have is that's your client's fault. That is your client's fault. So what we're concerned with is that you're asking us to delegate the decision as to whether or not a plaintiff gets damages, or gets back pay, I should say, in an age discrimination case to employers under the H-1B program. It's hard to see why that's a good idea. Can you tell us why that's a good idea?
Certainly, Your Honor, because injunctive relief remains available under the Age Discrimination Act, and the Immigration Reform and Control Act provides for civil...
What would the injunction say? What would the court say in the injunction?
Don't violate the law.
Yes, Your Honor. In EEOC versus Johnson and Higgins, the Second Circuit Court of Appeals issued an order to enjoin an employer from enforcing a discriminatory retirement practice under the Age Discrimination Act. This court could enforce injunctive relief.
How would that help? How would that help the respondent in this case? How would an injunction help the respondent?
While the respondent may not be able to recover damages personally under this case, it would punish the employer for violating the Age Discrimination Act.
How?
It would deter the employer from committing further violations of the Age Discrimination Act.
That might have been an interesting statute, but Congress adopted the Age Discrimination Act and explicitly provided plaintiffs with the right to sue. What you're suggesting is through another act, wholly unrelated, that has been applied in cases of malfeasance by the plaintiff, by this court, that Congress naturally would assume they would cut out a remedy in an unrelated statute whose primary method of enforcement is through a discrimination claim by the plaintiff. And I guess I'd like to know how you think Congress said that. Is there legislative history? Is there some enactment, some statement that you can point to that would give us some direction as we try to interpret Congress's will?
Certainly, Your Honor, and that's that Congress intended for the Immigration Reform and Control Act to end the magnet of employment that lures illegal aliens to this country.
She wasn't lured by illegal employment, was she?
No, Your Honor, she was not lured by illegal employment, but she was illegal at the time of her discharge. There can be civil sanctions and fines under the Immigration Reform and Control Act for an employer who does, in fact.
Excuse me, why was she illegal at the time of her discharge?
Wagner transferred Dr. Maida to a new position within the company when her research as co-director.
What administrative authority do you have to say that she was out of status or, quote, illegal in this country?
Certainly, Your Honor. Section 214.1E of the Federal Regulations for the National Immigration and Nationality Act says that a non-immigrant who is authorized to work in the United States may only engage in such employment for which he or she has been authorized. Any unauthorized employment results in a failure to maintain status.
And do you have any administrative interpretation or case authority that says when you stay with the same employer but change job duties that becomes unauthorized employment? Because the regulations also say there's no automatic revocation of the validity of the petition for a change of job duties. It's only a revocation by notice and opportunity to respond. So given that CIS here did not make any notice to the company and give the opportunity to the Wagner to respond, I don't see how you can now take the position she was automatically out of status.
Well, Your Honor, had the immigration authorities learned of her employment at Wagner as chief lab technician, the Immigration Reform and Control Act and the Immigration and Nationality Act make it clear that her immediate termination would have been required, which is why she cannot recover any damages that represent wages she could not have lawfully earned in the United States. Additionally, she cannot be reinstated to a position that she was never authorized to hold. Injunctive relief, as opposed to monetary damages under the Age Discrimination and Employment Act, can effectuate the Act's purpose without infringing on the substantive provisions of the Immigration Reform and Control Act. The Immigration Reform and Control Act governs, as this court already decided in Hoffman, and certain remedial provisions of other federal labor and employment statutes must bend to immigration policy when...
Just one last question. Would your injunction automatically then reinstate anyone who was over the age of 40 who was also let go in this reduction in force? Because you seem to be saying, give us an injunction if we could find that we did indeed violate the Age Discrimination Act, or would the injunction in your world be only limited to Dr. Mehta?
In this situation, Your Honor, the injunction could come in several forms. There could be an order to enjoin the employer from utilizing the ad campaign or from using certain criteria in the reduction in force, or just in general to prevent future discrimination at Wagner. I see my time has expired. May I brief? Thank you.
Thank you. We'll hear from the respondent.
May it please the Court, Chief Justice, Your Honors, my name is Joseph Comer, and along with my co-counsel, Simi Botich, we represent the respondent in this matter, Dr. Anjali Mehta. Respondent respectfully requests that this Court affirm the 13th Circuit Court of Appeals with regards to both issues on certiorari. I will be discussing why the 13th Circuit correctly held that the McDonnell-Douglas framework applies at summary judgment in an ADEA case. My co-counsel will discuss why an unauthorized alien employee is entitled to relief under the ADEA. Your Honors, the 13th Circuit...
Think you have the easier case here, counsel?
I'm sorry, Your Honor?
Never mind.
Wants us to think so.
Your Honor, the 13th Circuit was correct in adopting its standard for summary judgment in an ADEA case for two reasons. First, this Court's decision in Gross does not alter the McDonnell-Douglas framework, And second, the 13th Circuit correctly adopted a less burdensome McDonnell-Douglas test and found that respondent has brought forward sufficient evidence to create an issue of material fact.
Let me ask you a question I asked petitioner's counsel, and that is, if your client was unauthorized to work in the job from which she was laid off, the lab
Yes, sir.
technician's job, does she qualify under the McDonnell-Douglas test as a person who has the ability to do the job, has the qualifications to do the job?
Yes, Your Honor, she would still be qualified to do the job. Although her legal immigration status changed, she still was qualified from an employment perspective to maintain her job.
Why should we limit that to skills in an employment perspective? I mean, shouldn't there be other, couldn't we have a broader test that says if you're unqualified for any reason, legally unqualified or skills unqualified?
Because, Your Honor, the ADEA does not consider and does not speak on the fact of an individual's immigration status. And so we must read the ADEA in conjunction with IRCA to determine her status.
Suppose she were an escaped convict
Yes, Your Honor.
who secretly got a job, and then the FBI tracked her down and found out that she was supposed to be in jail. Do you think the person who had that status could be qualified for an ADEA award if they filed a charge of that type?
Your Honor, potentially no. However, Ms. Mehta's status only changed and she only became unauthorized because of Wagnera's action of demoting her and not filing the proper paperwork.
Counsel, why do you think she's unauthorized? I mean, maybe today because it's past the end of her validity of her H-1B petition, but at the time she changed job duties, why do you take the position she's unauthorized?
Your Honor, respondent takes a position she became unauthorized based on the conditions of her H-1B visa, as it specifically limits her duties to perform those as the chief lab technician. And so when those duties changed, there is a duty on the employer to update the visa and address her new position.
Could she have filed an amended petition on her own? Could she have filed with the Citizenship and Immigration Service saying, let me update you as to the company's changed rules?
No, Your Honor, and that is why Wagnera failed its duty to update it, because under an H-1B visa, it is only the employer that has the power to change her status. And my co-counsel will address that further of why Wagnera failed that duty.
Counsel, let me bring you back to the McDonnell-Douglas test. The logic of the McDonnell-Douglas test is that if we disqualify through the evidence put forward by the plaintiff the two likeliest reasons why an action would be taken against an employee, that the next likeliest reason is, in the case of McDonnell-Douglas, race discrimination. Right? It was our view at the time, and it's still my view, that race discrimination is so pervasive that it is reasonable to presume that race discrimination is at work if you eliminate qualifications and availability. Is age discrimination as pervasive and egregious in our society as race discrimination? And doesn't your argument depend on a yes answer to that question?
No, Your Honor.
Counsel, don't you necessarily lose then?
No, Your Honor, because Title VII directed the Department of Labor to conduct a study regarding age discrimination. And the Department of Labor study, in fact, found that age discrimination was extremely pervasive in the workplace.
But not as bad as race. Do you concede that?
Yes, Your Honor. But
okay, so then if we use McDonnell-Douglas in age discrimination and we eliminate the two likeliest reasons why an action would be taken against an employee, there could be 6 or 8 or 10 other reasons unrelated to age discrimination that are the default position. Isn't that right, counsel?
Yes, Your Honor. However,
then why should we use McDonnell-Douglas at all under the Age Discrimination Act?
Your Honor, as this court has stated, the ADEA was derived in hoc verba from Title VII. The purpose
Yeah, but we abandoned that in gross, counsel.
But, Your Honor, the purposes statute, the language, in fact, because of, is the same in Title VII and the ADEA. The only elimination under gross was the mixed motives claim, and Ms. Mehta is not alleging mixed motives, only disparate treatment. And, Your Honor, the point of the McDonnell-Douglas test is to force the employer to articulate a legitimate reason, because discriminatory animus, whether it is racial or age-based, is never going to be directly stated to the employee for the reason that they were terminated.
The only reason to require the employer to state a legitimate non-discriminatory reason is if we think that absent a statement like that, age discrimination is the next most likely reason. Can you tell us why that's true?
Yes, Your Honor, because at that stage, the plaintiff has already come forward with evidence and their prima facie case showing that that raises an inference, as Your Honor pointed out, that age discrimination was present in the case.
Why? That's my question. Why should we take that policy position?
Because Congress recognized that age discrimination is pervasive in the workplace, and that to avoid the stereotypes that all older workers' abilities deteriorate regardless of their individual case, to ferret out those discriminatory motives that could be behind those stated reasons, we must use this burden-shifting framework to really get at the true reason. And Your Honors, in Gross, this court was only addressing the burden of persuasion and not the burden of production. And this court has stated in Texas Department of Community Affairs versus Burdine that the burden of persuasion never shifts to the employer under the McDonnell-Douglas test. The McDonnell-Douglas test is an assist to get us to the trial phase so that we may make determination, in this court's words, whether there was discrimination vel non.
So the burden of going forward shifts, just not the burden of proof.
Yes,
In
Your
other words,
Honor.
the employer has to put up why it is that he thinks this is a protect.
Yes, Your Honor. And there's no burden of persuasion placed upon that employer. However, once the case moves to trial, as the First Circuit stated in Zapato versus Carlos, those first two elements of the McDonnell-Douglas test essentially disappear, and the issue is discrimination vel non. And
Mr. Comer, assuming let's assume for a second we don't know what the standard is. So it could be Gross, it could be McDonnell-Douglas. Ultimately, you guys have to prove up your case. And your friends on the other side have told us that there just is not enough in this record to let the case get to the jury. And frankly, I want to tease that out from you a little bit. There's no direct evidence that it was age, that no one says, you're too old, you can't work here anymore because you're an old person. You don't have anything like that in the record.
No.
What you have is a bunch of stuff about a company that's in the business of enhancing youthful appearance. That's its business. And that she's just not very good. So that's what they said. There's just not enough there to get to the jury. How come there is?
respectfully, Your Honor, that characterization of the evidence would be wrong.
I know it, and so tell me why it would be wrong. I know you're going to say that, so
Yes, Your
tell
Honor.
me why it's wrong.
As this court stated in Gross, there is almost never going to be direct evidence available.
I don't want gross. I want the facts of this case
Yes, Your
that you
Honor.
tell me get to the jury.
And there's circumstantial evidence that allows us to get to the jury because,
Lay it out.
yes, Your Honor, there's a pattern of discrimination related to Ms. Ross's comments stating that Ms. Mehta was in need of a little Juventus herself, the anti-aging drug, suggesting she was too old to work there. Furthermore, there is a clear indication on page 3 of the record that Ms. Benatar demoted Ms. Mehta for the sole reason of placating Ms. Ross. And there's a tribal issue of fact here about whether Ms. Ross continued that influence on Ms. Benatar at the termination decision. In
That's
fact,
a material issue of fact in your view?
yes, Your Honor, because pretext is one of the issues under these cases. And it is potentially able to show pretext that they considered some factors, but that ultimately Ms. Ross influenced Ms. Benatar's decision. In fact, the record shows that Ms. Ross had the opportunity to be at the final meeting to choose who is terminated. The record doesn't state explicitly, but we know that all upper-level management individuals were present at that meeting. And if Ms. Ross was present, which is something that could be elicited certainly during her testimony at trial, then Ms. Mehta would be able to show that there was pretextual reasons for her firing.
Because she was present at the meeting?
Because she influenced Ms. Benatar's decision to terminate Ms. Mehta specifically.
Because she was present at the meeting?
It could allow a permissible influence that the influence already
This isn't
shown.
a coulda, woulda situation. It has to be something more for a material issue of fact. It's not simply a metaphysical concept.
No, Your Honor. And I'm discussing this piece of evidence individually, but as the First Circuit noted in LeBlanc versus Great American Insurance Company, discrimination cases, the evidence as a whole must be looked at to determine whether there was discrimination. And the district court erred by picking out each piece of evidence and deciding whether it alone could move the case forward. When the evidence as a whole was looked at, the age campaign, the comments, the statistical disparities together show that there was a pattern of discrimination directed towards Ms. Mehta. Your Honor.
Counsel, so let me understand then that what you're making a statement to us is that we can add to the record that the district court ignored the behavior of Ms. Ross because we can allow the jury to make a decision whether or not she was part of the management structure that was responsible for making this firing decision.
Not exactly, Your Honor. The jury may make it permissible influence that she influenced Ms. Benatar in making the termination decision. And certainly at this stage in litigation, all inferences are supposed to be viewed in a light most favorable to Ms. Mehta.
Counsel, can I just ask, if we decide that McDonnell Douglas does not apply to the ADEA, do you lose?
No, Your Honor. Ms. Mehta's evidence still shows circumstantial evidence, which is, as this court stated in Gross, is continued.
Should we just ignore the McDonnell-Douglas issue? It seems to me, this is picking up on Justice Matasar's point, that it's irrelevant at this stage. Once there's a legitimate non-discriminatory reason in the case, as we said in Desert Palace, then it's all about discrimination. Can we show discriminatory intent? Either there is or there isn't. And in this case, whether there's either a genuine issue or there's not a genuine issue, as Justice Barr is saying, the Chief Justice is saying. So why are we even talking about McDonnell-Douglas? Why don't we just get to the question of, frankly, a question not for this court, another court, whether or not you put forward enough evidence?
Because, Your Honor, the McDonnell-Douglas test forces the employer to articulate a legitimate reason. And in any of these cases...
They have here, right? They've done that. You don't deny that they've put forward a legitimate non-discriminatory reason that satisfies the Burdine requirement. Am I right?
Yes, Your Honor. However...
So then why are we even talking about McDonnell-Douglas?
Because it's still an important tool at summary judgment, Your Honors. They should still be forced to articulate that legitimate reason.
But they did. That's what I'm trying to get past. They did that. You, as a factual matter, not as a legal matter, you won that argument. You forced them to come forward. They did. Why are we even... I can't figure out why we're talking about McDonnell-Douglas, other than that we've been asked to.
Well, Your Honor, the respondent has brought forward evidence to show pretext and show that this case should go to a jury because looking at the evidence as a whole, there were a number of factors that were considered in Ms. Mehta's termination, and we don't know what weight was given to each of those factors. So if a jury were to find that insufficient weight was given to reasonable factors and reasons that were subjective and potentially pretextual were given too much weight, that would allow Ms. Mehta to succeed in this case. And so the McDonnell-Douglas framework moves us along at summary judgment, but the respondent agrees that at trial that is her ultimate burden and that this evidence, when viewed in a light most favorable to her, does show that there was potentially but-for discrimination. Your Honors, it's also important to note that the 13th Circuit correctly adopted the lower burden of showing that a similarly situated younger employee was retained to move the case along.
Mr. Comer, that can't be the right standard, though, right? Which means anytime you're in a protected class and you're let go, as long as you can find someone who's younger than you are, then you've made out your case under McDonnell-Douglas?
Someone who takes your place.
Your Honor, it's simply a...
Here there was no one taking anyone's place because they were laying off people.
That's what he's going to tell us, right?
Yes, Your Honor. Not necessarily taking their place, but retained in their place.
There were some folks who were about her age who were retained, right?
There were, close in age. But as this court noted in O'Connor versus Consolidated Coin Corp., it's not so much whether they were exactly in the protected age group or not. It is the disparity in ages that just arises an inference of discrimination, and she still must bring forward other circumstantial evidence to ultimately succeed in this case, which she has done so. Your Honors, the evidence, the aging campaign shows a long impact of ageist policies in this workplace. Yes, it was part of the ad campaign, but it was also influencing the decision makers in deciding who to terminate and who not to terminate. And in a reduction in force, it's in fact more important to force the employer to articulate that legitimate reason and to get into the mind of the employer and determine whether there is discriminatory animus. And because at this stage of the litigation, all inferences are viewed in a light most favorable to her, these numerous pieces of evidence that she has brought forward should move this case along to a jury trial.
And Mr. Scrimmage, just on the merits, if we get to there, suppose that we let this case go to the jury and their evidence at trial were to say, the reason we let her go is we hired her for a higher position, which she wasn't very good at. We tried to give her help on this lower position that she was okay at. And we figured as long as she was someone who didn't really qualify for the thing we hired her for to begin with, we let her go. Would that be enough to withstand your argument?
Ms. Mehta in that case would have to show that those reasons were pretextual, and the sufficiency and weight of factors for that termination decision would have to be looked at by the jury and whether there was an inference of discrimination there. I see my time is up. If there are no more questions from the panel, thank you.
Good afternoon. Chief Justice, Your Honors, may it please the Court, my name is Simi Bowditch, and I too represent the respondent, Dr. Mehta. Respondent respectfully requests that this Court affirm the 13th Circuit and find that Dr. Mehta is eligible to recover under the Age Discrimination in Employment Act for the following 3 reasons. First, because this Court's opinion in Hoffman Plastic Compounds Incorporated versus the National Labor Relations Board should be read narrowly as applying only to the National Labor Relations Act. Second, because allowing Ms. Mehta the right to remedial protection under the ADEA is in line with the Immigration Reform and Control Act. And third, even if this court should choose to apply Hoffman to the present situation, this case is distinguishable and Dr. Mehta is still able to recover. Your Honors, turning to my first point, this court's opinion in Hoffman should be read narrowly as applying only to the NLRA. This court's opinion in Hoffman strictly stated that it was limiting the board's ability to select and fashion remedies.
Counsel,
Yes, Your Honor.
you have a number of problems. Let me point out one. The language of both Title VII and the ADEA, the remedial provisions of those two statutes, are almost verbatim from the National Labor Relations Act, including the concept of affirmative action, back wages. All of that comes right out of the National Labor Relations Act. Shouldn't we take judicial notice that an interpretation of the remedy provisions of the NLRA, which is what happened in Hoffman Plastic, should influence, at a minimum, influence our interpretation of the remedy provisions almost identical in Title VII and the ADEA?
No, Your Honor, and for two reasons. First, because the NLRA and the ADEA are distinguishable in the way that they are enforced and also distinguishable in their remedial schemes. First, the NLRA is enforced almost entirely by the board. The ADEA, on the other hand, is enforced almost entirely by private litigants. This court itself stated that private litigants under the ADEA are almost always forced to come forward and defend themselves and to defend the purposes behind the ADEA. Additionally, as I stated, the NLRA and ADEA are different in the way that in their remedial schemes. The ADEA Congress rejected the NLRA's remedial scheme when it adopted the ADEA, and the ADEA's remedies are intended to be punitive in nature and are intended to have another purpose in addition to the NLRA, and that is to punish employers for discriminating against individuals. The NLRA is only intended to be remedial. And
Counsel, is there any case law that we should look at of the EEOC's interpretation of whether Hoffman precludes remedies? Because I'm not sure we shouldn't be considering deference to the agency that's charged with enforcing these statutes.
Yes, Your Honor. After this court's decision in Hoffman, the EEOC came out with a press release on June 28, 2002, that stated the decision in Hoffman was in no way should in no way be interpreted as a decision that stated that an unlawful alien employee is not entitled to the protection of this country's workplace discrimination statutes.
We don't usually use press releases of agencies as entitled to deference. So is there any case law, regulatory law of the agency that indicates their position?
Well, Your Honor, there is case law that after IRCA was enacted and the decision in Hoffman, that other courts have held that federal employment laws do protect undocumented workers. And that is under both Title VII and the FLSA. Additionally, Your Honor, because allowing the remedial protection of the ADEA for Dr. Mehta would in no way violate the policies of the IRCA. Allowing her protection would not condone or encourage employee violations of IRCA.
Hey, Counsel, why isn't your remedy under the immigration law itself? As I quoted to your opponent, in provision 8 U.S.C. 1182 INA section 212N, there's a specific provision for your client to have made a complaint through the Department of Labor for back wages, for the Department of Labor to even gotten sanctions against Wagner. Why aren't you limited to that remedy?
Your Honor, because in this case, Dr. Mehta was here on an H-1B visa, and it was the duty of Wagner to update that visa or to renew the visa for the new position that they moved her in.
What's the source of that duty, Counsel?
Your Honor, the source of that duty is 8 CFR section 214.2, which specifically places the duty on Wagner to update or renew the H-1B visa.
Only if they wanted her to stay. Isn't that right? They're not obligated to keep her if they change her job. They could simply say, time to go. We're not going to renew or modify your visa.
Your Honor, it was their duty if they were going to move her in a position within their company. They had the option to discharge her at that time when they moved her from the position that she was authorized by her H-1B visa, and Wagner did not do that. So yes, Your Honor, the duty is still on Wagner to renew her visa for the new position.
But if your client, doesn't that put an equal burden on your client that if she is out of status, she needs to leave the country? She was illegally present or illegally working in the country at that time. Isn't she obligated either to stop working until her visa status is resolved or leave?
No, Your Honor, she was not obligated to stop working or leave at that time. In fact, IRCA makes two things unlawful. One, for an employee, it is unlawful to use fraudulent documents to obtain work in the United States. That was not done by Dr. Mehta in this case. It also makes it unlawful for an employer to hire an unauthorized employee or to retain an employee once that person has become unlawful. Neither IRCA nor any other statute makes it unlawful to be a worker in this country but undocumented unless that work was obtained using fraudulent documentation.
It's your position, and I want to see how heavily you're going to lean on this, that it is legally permissible for a non-immigrant, which is what H-1B workers are,
Yes, Your Honor.
to work out of status in the United States. So, for example, somebody on a tourist visa, also a non-immigrant, could spend 6 months welding bridges in Dallas.
Your Honor, while it is not lawful for someone to stay in the United States once their visa has expired or no longer authorizes them to work here, it was not the duty of Dr. Mehta in this case to update her visa. And in fact, she did not even have the power to do that under the statute.
So it's unlawful, but she has no duty to stop the unlawful behavior. Is that your position, counsel?
Yes, Your Honor. And in this case, Dr. Mehta concedes that at the time that she was working as the chief lab technician, that she was not authorized by her H-1B visa to work here.
But you're not saying, or are you saying that it was the employer's responsibility to do this, to change the status? Is
Yes,
that
Your
what
Honor.
your position is?
Yes, Your Honor. As stated in 8 CFR section 214.2, it was the employer's
So what
duty.
does Mehta have in the way of responsibility for this problem that is apparently befallen her?
Your Honor, under the statute, Dr. Mehta did not have a duty to renew the visa, and she is not even given the power to do so.
Ms. Bowditch, just to push you a little bit on this, we beat up on the company already for their failures, but as I understand the record, your client explicitly invited those folks to come visit her in India. She pitched a job to them. She had as her motive to get to the United States to be closer to family members. Isn't she taking on some responsibility to assure herself that if that's her goal, that she fulfill the responsibilities under U.S. law before she's allowed to take advantage of remedial statutes meant to protect people who are lawfully here?
Your Honor, absolutely.
Wouldn't Congress, in passing IRCA, be somewhat concerned that someone who's not legally employed in the job that they're employed in be given these expansive rights to be able to use the court system when the person themselves didn't take much in the way of effort to assure their legal status?
Your Honor, there is nothing in IRCA to indicate that it intended to eliminate remedies for undocumented alien
That
employees.
always bothers us when we look at congressional statutes, but it's our job to try to interpret what the expanse of the act is, and in looking at Congress's intent to deal with the problem of undocumented workers or illegal workers in the country, it's pretty clear that Congress wanted to get tough on that. Now we are sitting here at the intersection of complicated federal statutes trying to gain an appreciation of what Congress would have intended. And I might feel differently in the record if there was some evidence that your client was trying desperately to keep her status legal, but she's shown no efforts whatsoever. So why should we feel in that kind of a situation a strong affinity for her and a strong affinity for the remedial statute versus thinking that Congress, were they confronted with this situation, would believe it's a bad idea for us to extend the right to sue?
Your Honor, under IRCA, Congress specifically did not make it unlawful for an alien employee to overstay their visa. It made it unlawful for an employer to maintain an employee in that situation. That explicit language is direct evidence that this is in line with what Congress would have intended. Additionally, Your Honor, while Dr. Mehta did want to work for Wagner Incorporated, and she did the best work that she could for them, and she did want to be close to her family, none of those things are a crime. The crime has been committed by Wagner for bringing her here, moving her into a position which she was not authorized for, threatening to remove her H-1B visa if she did not move into the new position.
Counsel, how is this relevant to the cause of action you brought? You brought a cause of action for age discrimination. You
Yes,
didn't
Your Honor.
bring other tort actions about unlawful contract violation of state employment law, intimidation, any tort actions. You haven't sought an action under the INA for the back pay remedies that you're entitled to there. I understand you're trying to win our empathy from Dr. Mehta, but why is it relevant to age discrimination?
Your Honor, it's relevant to age discrimination because at this point, Dr. Mehta needs to show that she is eligible for the remedial protection of the Age Discrimination in Employment Act. That is why this is relevant, to show that she can even come before this court and seek a remedy. And in this case, Dr. Mehta has shown that she can. Your Honors, even if this court should choose to apply the Hoffman rationale to the present situation, Dr. Mehta can still recover because this case is directly distinguishable from the case in Hoffman. In Hoffman, this court precluded back pay for an unauthorized alien employee who used fraudulent documentation to obtain work. Here, we are dealing with a completely opposite situation. In the case of Hoffman, the employer did not have any knowledge of that person's unauthorized status and additionally did nothing to violate IRCA.
Counsel, is that a question for us or is that a question for the district court?
Your Honor, this is a question for this court, if this court should choose to apply Hoffman, to see that it is distinguishable and therefore, even under this court's rationale in Hoffman, Dr. Mehta would still be eligible to recover.
Actually, I have a follow-up question to that point.
Yes, Your Honor.
Because you seem to have conceded that she was out of status as of resuming the duties in a lesser position. But what about the unpaid leave that she took? Why is she in status when she's on unpaid leave?
Your Honor,
isn't that for the district court to make some determination of, as my Justice Harris was just saying, for the district court to determine whether that's factually distinguishable from somebody who presents false documents?
No, Your Honor. In the position when she was put on unpaid leave and then when she was moved into the skin allergy department, she was unauthorized to work here under her H-1B visa, but that was only because of the prohibited actions taken by Wagner Incorporated. Additionally, they did lead Dr. Mehta to believe that it may have only been temporary, which is stated on page 16 of the record. She believed that they may have been moving her back in to her old position if progress was made on Project Juventus, and she was specifically told that. She was also told that Ms. Ross had made threats to send her back to India, and that if she did not take the new position, that her H-1B visa would be revoked, which there could also be an inference drawn that she was led to believe that her H-1B visa still authorized her for that position, or that Wagner Incorporated had taken the necessary steps to renew the visa for the new position. Your Honors, the claimant Castro in Hoffman used fraudulent documents to obtain work in that situation, and the employer in no way violated IRCA. Here, Dr. Mehta did not use fraudulent documents. She came to this country completely legally on her H-1B visa, and the employer in this case knew of her unauthorized status when they moved her to the new position. Therefore, this court's rationale of wanting...
There are remedies, though, in IRCA for the employer, right?
Remedies for...
There are remedies for the employer's misconduct in this case under IRCA. Isn't that right?
Your Honor, under IRCA, there are sanctions available against the employer.
And back wages, as a general matter, are not punitive. They're make-whole remedies. Isn't that right?
Yes, Your Honor.
So how... If your goal seemingly is to punish the petitioner in this case, understandably so, how does giving you what you're asking for in this case serve that purpose?
Your Honor, first of all, the sanctions that are made available under IRCA are hardly enough in this case to deter the employer from future violations. May I briefly conclude?
Right.
Yes.
And the House Judiciary Committee specifically stated that the employer sanctions under IRCA were in no way intended to diminish existing labor law protections that existed in the law at that time. Thank you, Your Honors.
have 2 minutes. Is 2 minutes you want? Yeah? Sure.
Just one brief point on rebuttal, Your Honors. Opposing counsel contends that Hoffman should not be extended to the ADEA because the board is the primary enforcer of the NLRA, whereas private litigants bring claims under the EEOC. As this court noted
They've also distinguished it on the facts, but we'll go ahead.
As this court noted in EEOC versus Waffle House, the EEOC has broad authority not only to investigate individual instances of discrimination, but also to investigate discrimination independently in an effort to eradicate it from the workforce. Thank you, Your Honors.
Very well. I suppose we'll take a few minutes to discuss all those large thoughts. Don't go far away.
Taking the case under advisement.
I almost forgot my
All rise.
seating. I gather our task, a hard one, as you could tell from the length of time it took us to come back, is to pick both the team and the individual best oral arguer. And our unanimous view, after a little arm twisting, is that the petitioner team wins, and Mr. Comer wins as the best oral argument. We're each going to say a few words, or maybe. Judge Matisar seems to want to be the one to thank you, but I'm going to steal that thunder and thank you all. I thought you were all very good, and I thought you were all extremely well prepared. I just have a couple of thoughts that I would leave with you about oral arguments generally, and frankly, I have an awful lot of them because I allow everybody that chooses who has a dispositive motion, not necessarily a dispositive motion, to have oral argument if they ask for it. Frequently, I'm not sure they need it. Sometimes I think it hurts, but I let them argue. And one thing that bothers judges, or at least bothers me, is that you really, well, I guess everybody that stands up has to listen. But what they don't always do is they don't always answer questions that are put to them, and it really is very sort of off-putting for the judge to ask a question and to hear an answer that really is sort of to the side or to the right or to the left, but not answering the question directly. So I would urge you to listen carefully and answer the questions directly. I think some of you, I think all of you need to make eye contact with the court, and if there are 5 of us, or even if there's easier when there's only 1, I guess, you ought to make sure you do that, and some of you did that. I guess all of you tried, but I got more of it from Ms. Botich, I think, than I got from others of you in the way of eye contact. And I think it's a valuable weapon. At least it keeps the judge awake. I mean, if he sees you staring at him, he generally doesn't nod off. The third one is a little more 21st century, and that is, there are now any number of ways to find out what the judges you're going to have in front of you, obviously it's easier when you only have 1, are about. And that is something you ought to avail yourself of. I mean, if you had looked on Google, you would have seen a lot of nonsense about me, but you would have also understood where I'm coming from as a rule, so that you could, in a sense, pitch your argument in the best possible way. And it's likely that you would, I mean, you'd have a lot of trouble screwing that up. I mean, if you looked up who the judges are. So I would urge you to do that. But on balance, and those are my only large, not so large thoughts, but again, I thought all of you did really well. Why don't we start from the side and ask Lenny Benson, Judge Benson, I lost my head.
Yeah, well, my favorite title is Professor Benson. I am a professor here at Newark Law School, and just to the competitors, you are all really quite excellent, and this was a tough problem, and I probably asked the meanest of all questions because I live and breathe the INA. That's the Immigration and Nationality Act. And just to brought a prop here, you know, this is the Immigration and Nationality Act statute and regulations and its selected forms. And that's where Jeff Lina, who is one of the students who is in my immigration class, got involved with Hoffman, because I teach it at the very opening of the class. You know, what is this relationship between status and the right to be in the United States employment? And I want to thank you all for doing as well as you did. And I just would like to make a note to all the audience and to the faculty advisors that are here, and maybe the students who couldn't be here, who worked on this competition, that in truth, the question I was asking about the remedies under the INA itself, if we were really plaintiff's counsel on behalf of Dr. Mehta, we might have come back with more money if we had sued for violation of the LCA and the H-1B than we would have won under the ADEA. So the moral of that story, whether you're defense counsel and you're offering some kind of settlement, or you're looking for posture, or your plaintiff's counsel, is everybody needs to know a little immigration law today. So that was an advertisement for my class will be offered next year in the fall. But I also think you're all excellent arguers. I do want to say, though, that I gave you a really tough time about Hoffman and the statutory interpretation and the dates of the passage, and that meant to me respondents' team should have picked up on the argument I made, and it is a harder role to be the respondent. You have to pick where the bench is going and then play with the ball. And so to all of you, I would say it follows up on Judge Baer's comment about listening, is judges are not neutral vessels, right? I mean, they try to judge appropriately, but they do come with points of view, and you listen to them, listen to their arguments, and then see what you can use to hit the home run. But really, all 4 of you, excellent competition, excellently well run. Thank you, New York Law School, for allowing me to participate.
Well, first, I want to thank you for excellent presentations. I was sitting here kind of marveling at the fact that here you are still in law school and yet have so much self-possession and obvious talent, and I think it speaks very well for your schools and for yourselves that you've done so well in this competition to this point. I endorse what's been said before about oral argument. I will say one additional point, and that is many times in oral argument, you can take something that a judge says, and you got to be quick on your feet to do this. And sometimes you're taking a little bit of a chance too, because you may not know it, you may not be reading the judge right. But it is important to try and if a judge gives you something that you think you can go someplace with it, that means that judge is interested in that topic. And I think it's a smart thing to do. And again, you've got to be pretty quick on your feet to do it, but to try and incorporate that judge's concern to the extent it supports your argument, or address that judge's concern if it doesn't support your argument. And so I think those of you who will continue to do this as part of your practice should incorporate that into your arsenal of oral argument techniques, because it'll be very helpful. But I thought you all did a wonderful job. This is the third year I've been asked back to be on this panel. This was, I probably asked fewer questions this year than I did before, because I thought the arguments were all so good. I was just kind of interested in hearing them. And my colleagues were doing a great job answering questions too. But thank you very much, and good luck to all of you.
Judge Harris, you have some thoughts?
Thank you. Let me start by, I should start by saying everything that's worth saying has already been said, just not by me. So I want to start by congratulating the authors and the co-chairs of the Wagner competition and the faculty advisors who never get it. As a former faculty advisor to this competition, let me say, never get enough recognition in this process. You all did an excellent job. You came up with a very difficult and I thought interesting problem. It was a well-written bench brief. I really enjoyed participating, and it's a pleasure to come home. This is my first time in this in our new home at New York Law School, and it's beautiful. And the arguments rose to the surroundings. Let me just say. Let me just say, I think you all could have praised the Labor Department much more lavishly. That would have won.
And the NLRB too.
The NLRB got a little too much attention, if you don't mind my saying. We have a little competition. I thought, again, repeating what's already been said, you all did an excellent, really a wonderful job. I can tell you from my limited experience as a clerk on a court of appeals, the arguments that we see here in the Wagner competition, particularly in the final round, so far outstrip the average argument that one sees in a U.S. Court of Appeals that it's really a pleasure to come back and watch you all perform, which you did, I thought, brilliantly today. To the petitioners team, you were unmovable. You were absolutely unmovable. And I've played basketball against people like that, and it's my least favorite thing. You can't get them off the spot. We could not get you off the spot. And I thought you really did an excellent job advocating on behalf of your client. We actually had a little friendly disagreement in chambers, such as they are, about which side had the harder argument. And on the facts, it may have been respondent. On the ideology, but given the makeup of this particular court, it may well have been the petitioners. And I thought you did a good job responding to the questions that you heard. And I was favorably impressed by all of the participants' really encyclopedic understanding of the facts and the applicable law. This was not a simple record. And I thought that you grasped some nuances in the record that other competitors might not have picked up, and that really distinguished the argument here. I thought you went deep into the argument. As for the respondents, I just love the style. It's somewhat, while they were absolutely solid and unbending, which is a perfectly legitimate style argument, you were much more sort of seemingly relaxed and loose, and I thought it's more. Because it's more like my style, I really appreciated it more. But I thought you both did an excellent job. This was a hard case, and I thought you all did a terrific job fleshing it out and responding to what we had to say on the panel. So thank you very much for allowing me to participate.
It's great to welcome Chicagoans to New York. I grew up in Chicago. I get the accent. Oral argument frequently is distinguished by losing, not by winning. Okay, so you can come to an oral argument and absolutely screw up your case if you're unprepared, if you're inflexible, if you don't listen well to judges, and if you basically don't treat the oral argument as an exercise in making the best you can out of what you've got. And what's nice to see an argument like this is that you've understood that your main role here is to try to be helpful to the court, to take your case and make the best positions you can. And from a perspective of a non-judge who judges a lot of moot court, I always enjoy when we get to the final round because you see the best of the best, and you clearly all were the best of the best. And that's really exciting and fun, and I only wish that I had a job available for all of you after graduation. I hope you're all working. If you're not, stay here, come to graduate school at New York Law School. But it's a great future that you can see in line for the people who've put the effort in that you've all put into doing the prom. And I want to thank you for your participation and being here. I like to go last a lot of these things because I want to sort of begin with saying it's a Sunday afternoon. It's raining outside. There has to be something in your life that would be more fun. But there's a huge investment of time and effort by all the people that are here, beginning with our judges who have incredibly active and busy careers. They're here. And this is a give back that I think really demonstrates the best of what our profession has to offer. Those who are senior give back to those who are junior. And the moot court experience gets you very low pay. Okay, even our prizes don't do all that much for the judges that are here. And yet, every year, great people will come back here and be judges and spend time with students because they see their serious obligation as a senior member of this profession to help those who are succeeding them become better. That's true about third-year students with second years. It's true about faculty members who come back. It's true about our graduates that come back and volunteer. And essentially, it's true that as you all begin your careers, you're in a position to know that you are there to lead other people. And so I am very proud that we have this competition annually, and I'm very proud that we're part of a profession where people take seriously the responsibility to the public that they have by taking on these important roles, and to see it happening among young people before they've ever had a live client. I believe that you believe in your clients. I mean, if you can do it with a simulated client, you're certainly going to be there with the real thing. And that's, I think, all we can ask for is that the profession continues to provide the best that it can for the people who depend upon us to help them work through their life problems. So on behalf of all of us at New York Law School, I'm delighted that we've had the competition, and delighted for all of our teams, and certainly for these two teams who were just extraordinary. And everyone walks home a winner today. And so thank you very much.
Thank you to everyone. If we may, again, thank the final round judges. Get a round of applause for that. And then we'll bring out your awards.
And the cup.
So the national championship team was Loyola. Congratulations. Congratulations. We can do it later. The national championship runner-up. Congratulations to the team from DePaul.
And finally, the best final round oral advocate.
From DePaul's Joseph Comer. Congratulations, Joseph. We forgot to give you the cup when you give you the flag.
Let's take a photo. No.
You don't get to keep it, but congratulations, you can hold the cup. Thank you again to everyone.
Yeah, I know. Yeah.
And now you're all free to go.
Yes. Thank you again for coming.
Yes. Thank you very much.
Oh, we have no problem.
Thank you guys. Very good to see you in a row. Okay, all right, very good.
Congratulations. It's great fun. Fun for me. I don't know about you. loved it.
Really enjoyed it. Really enjoyed it. Great problem. Great athletes. Hi. Well, thank you very much for
Thank you. Austin.
Want to get one picture with the bench and the advocate?